Good morning, and thank you for joining us for today's Workers' Compensation 101 webinar. I'm Sarah McDonald from the Board's Stakeholder Engagement Unit, and joining me today is Joe Cavalcante, the Board's Advocate for Injured Workers. Today, Joe will cover the basics of workers' compensation system, including employees' rights if they become injured or ill on the job, employees' benefits under workers' compensation, how to file a claim, how to get help with your claim if needed, and best practices for injured workers. We'll ask you to please keep your phone lines muted as we'll be using the chat feature to receive your questions today. You may enter your questions throughout the presentation in the chat box located on the right side of your screen. Joe will answer as many of your questions as he can, but if there are any he doesn't get to, or if you think of something after the session ends, we will be providing you with additional resources at the end of the presentation. Your name and email are given to us when you registered. However, if you have a specific topic you'd like to discuss more in depth with the board, please share that topic along with contact information in the chat box so the appropriate board staff can follow up with you. The chat settings are set so that only panelists can see questions or comments that come in, so you don't have to worry about others seeing your contact information. So with that, I will hand it over to Joe, and we will get started.
Thank you, Sarah. Good morning, everyone. Today's session is, according to the sign-up, almost exclusively injured workers and their advocates, which is not typical. We usually have a much broader participation from the comp community, but that's perfectly fine. We're here for the workers. It is July 7, so maybe it's the injured workers who are, you know, living their lives. It's also, I must say, July 7, 2025. We want to wish a happy birthday to everyone's friend, Richard Starkey, who's 85 years old today. You might know him as Ringo Starr. So let's dive in and let's talk about what we can do to prevent incidents from happening in the first place. Let's have safer workplaces. Here is a suggestion that any workplace can adopt. It's known as the Labor Management Safety Committee. It is essentially people talking to each other. It's the workers who do the routine tasks and the managers thereof. Let's have the workers and the managers talk to each other on a regular basis. Let's have them meet and discuss the places in the work site that can create an incident or are creating an incident. And this is about safety, okay? This is not a claim review. That can happen in a different forum. But here, we just want everyone to note together, hey, there are incidents that are happening, or I could foresee an incident happening. What can we do to mitigate that or prevent it? You know, what's our training like? Who's doing the training? Are we training in the safest way to perform our jobs? And also, how about our equipment? Is our equipment being properly maintained and properly used? So in essence, anything that you can do to prevent incidents, this is a great place to discuss it. You should have a regular meeting. It's very simple, and it's free. Let's talk now about the workers' comp system and the workers' rights therein. This is a no-fault insurance system, similar to auto insurance in New York State, the no-fault. So that means who created the incident is not really a factor here. Okay, we don't get into issues of fault. There's this insurance coverage just in case there's an incident that injures someone. That's as far as we need to go with that. And it is an insurance system, so that means there will be an insurance payer somewhere in this process. And we'll talk more about that in a moment. The employers have to provide this insurance coverage, so that means no charge to workers for this insurance, as opposed to, say, these other two insurances my agency administers. That would be short-term disability and paid family leave. The workers can be asked to contribute a very small amount of money toward that insurance, but not workers' comp. All right, this is in place, and it is, well, I'm sorry, it's in place to help the workers get treatment and lost wages, and it's a worker's legal right, so that means it cannot be signed or negotiated away. Indeed, think of what we're going to tell you today as a minimum or a floor, because workers can and do negotiate richer benefits in things like collective bargaining agreements. The immigration status of the worker is not a factor, period. You don't have to worry about questions in this system about where you were born if you're a worker. We also like to point out that language assistance services are available to workers. We are showing you the board website that discusses the language assistance services that we have available in the, I believe we're up to 12 languages right now that things are readily available. And so we can also translate into any other language. You just have to request it. This is something we do for free for workers, for free. And here's a little fun fact, another fun fact. Queens has more languages spoken than any other county in the United States of America. That's actually my home borough. Yes, there's a little trivia about me now. All right, so the Workers' Comp Board, that is a New York State government agency, the employer of Sarah and myself, and this agency regulates and administers the workers' comp system in New York. We do not pay the claims unless, okay, I'll get to that in a moment. We administer comp, we also administer short-term disability and paid family leave, as I was saying earlier. There are about 1,000 of us all across the great state of New York. How do we do this? We receive reports of the injury and of the treatment and of the payment and all the other events in the system. So if there's an event in the system occurring and it's generating a document or a report, we should almost certainly have a record of it here. I only say almost certainly because maybe there's some unusual exception that I'm not thinking of, so that's why I said almost certainly. We also hold hearings when it's appropriate to move a claim forward. We have law judges, and that's a feature of the system you're probably familiar with in a popular sense, and we will speak about that in a little bit. Who is this advocate for injured workers? Well, he's talking to you right now. That's my title, and I'm the manager of an office of people. We help workers with the more difficult and the complex claims, and I would like to point out that my real civil service title is ombudsman. The law actually establishes my role, and it is the role of an ombudsman. So that means that I have to care about the health of the system, and therefore I might bring some questions forward at times, maybe to a payer, maybe to an insurer, or definitely to the staff here at the board internally about whether the system is properly functioning or whether an incident or a claim, and usually I mean like a claim or an IME, was properly handled and performed. My office and I are also involved in fatality claims. We will explain the fatality benefit in a little while. I am the board's liaison to the 9/11 community. Yes, my friends, this is ongoing. If you are following the news closely, you might know that the 9/11 advocates are in Washington right now and have been all this year to try and ensure that funds are not removed or are restored, or essentially that the people harmed by September 11 and the aftermath are helped the way they ought to be in the way that we all promised we would. We are showing you on screen right now 2 federal programs. On the left here, the World Trade Center Health Program. If you were impacted by the attacks or the aftermath, please, the health programs are still in existence. You can get medical monitoring and treatment for 9/11 related illnesses. On the other side of the screen, the September 11 Victim Compensation Fund. This is administered by the Federal Department of Justice, and they really, I can tell you, they really do care over at the Federal Department of Justice in this program here for the people who were harmed, and you can apply for actual monetary compensation. We have on screen here some phone numbers, and you can come to our web, or what's the URL here? You can go to this, you can see the URL on screen, okay? The web address.
My bar is covering it, I apologize.
Yeah, so we can't quite read it here, but you can see it. So please go to that site and find out more information if this is you or someone you know. Okay, new topic now. Who pays your workers' comp claim? This is what we call foundational. Remember I said that the board doesn't pay your claim? Well, the last bullet I'll drop down to first. The board will advance the payments for your claim if there's no insurance in place. And what will happen is we will make the payments and we will bill the owner of the business who was not carrying the insurance as it should have been. That person is in a bit of a bind now because that person is going to get penalized and is going to have to pay us back. You see, in insurance, it's called holding you harmless. We make that our problem. So if you're a worker, don't worry about who the insurer is. Just file the claim. If it turns out there's no insurance in place, don't worry about it. File the claim. We will sort it out. And what we will do is we'll either make those payments or we will find the real insurer. Now, how do the employers get an insurer? It's pretty simple. They do one of 2 things. They either buy a policy or they self-insure. They can buy an insurance policy from one of the approximately 290 companies. Yes, 290 companies wrote the insurance in New York State in 2023. The other way they can do it is self-insurance. Now, self-insurance is very specialized, and self-insurance means that the employer has the funds available to pay the claims out of its own resources. There definitely are employers who can do that. They tend to be either governments, and self-insurance is very popular amongst government entities like counties and cities, school districts. And it's also popular amongst the very largest private employers. We're talking about international multi-billion-dollar companies, usually. They're either international or multi-billion-dollar or both. So it's not going to be the flower shop on Route 146. That's not what we're talking about here. The thing that we'd like you to know is when employers choose self-insurance, they almost always hire a claim administrator to handle the actual claims. Like, think of a city like, just pick a city in New York. Let's say it's self-insured. Are the people in the city going to know how to do workers' comp? Well, for everybody except New York City, the biggest, it's highly unlikely they're going to hire an administrator. New York City is self-insured, and I'm calling out New York City because they're such a big employer. They're self-insured, and they created their own type of claim administrator. They have a specific section of New York City government, of city employees, whose job is to handle the comp claims. So they made themselves a little internal administrator, we'll call it. So that's a very long way of saying, if you have a comp claim, your manager at work is not going to know anything about your claim. Your HR department is not going to know anything about it, and they're not making the decisions on your claim. Now, we just had a question come in where someone's asking, what if the owner of the business is deceased? What do I do? Well, did the owner of the business buy a policy? If the answer is yes, then the status of the owner of the business or anybody else at the business is not a factor here. If a policy was purchased, the claim is the responsibility of the insurance company who wrote the policy. So, yeah, if we're talking about the owner of a business, we have to be talking about a policy here. And so if that owner, let's say the owner is deceased and did not buy a policy, okay, now we're back to the board's going to advance the payments. Okay, the policy terminated after the accident, the person is saying. Well, that does not impact the claim. Repeat, that does not impact the claim because the policy was in force when the accident happened. That means that insurance company now owns that claim. Because remember, employers absolutely change insurance companies. But the insurance company who had the policy the day the accident happened, it's their claim. You're very welcome. I love when people say thank you to us like that. That means they're hearing us and we answered the question. All right, who needs coverage? Well, businesses who have employees are required to have coverage. And when we say businesses, if we just say business, we mean for-profit, but here I'll be extra clear. For-profit businesses with employees, you must have coverage. Most nonprofits are also required to have coverage. Let's drill down a little bit further into the nonprofit world, etc. Okay. The key here is employees. So, who's an employee? Because we're going to spend a moment on that to the extent that there are employees, but then there are also independent contractors. And independent contractors, I can tell you, well, the term independent contractors, I can tell you, is a phrase that is vastly overutilized in comp world. I can say that because people who routinely get called independent contractors are not independent contractors for workers' comp purposes. How does that happen? Here's how it happens. The board, our employer, is the only party who decides for workers' comp purposes if someone is an employee or not. And of course, it could get appealed, so then possibly a court might. But we make the initial decision, okay? So we make that decision because anyone who's providing services to a for-profit business can be determined to be an employee. And if for purposes of buying a policy or having the insurance in place, you only need one part-time employee who's covered from the first minute. There's no waiting period on when coverage kicks in for comp. It's the first minute. And yes, there are people who do get injured or worse on the first day of employment, which is not really surprising because it's the youngest employees and the newest employees who tend to get injured the most frequently because they don't know the processes and so forth. So when now we come to the nonprofit world, anyone who's compensated can be determined to be an employee of that nonprofit. There are limited, obvious, explicit exemptions, such as clergy, teachers in a 501c3. The nonprofit can choose not to cover those people. They could choose to cover them too. And that's the other thing. Our advocate for business does a whole webinar where he talks a lot about this, but I'm giving you a lot of the same info here, and then he does a whole bunch of other things. So definitely check that out if you're interested. But my point here is, let's say you're a private employer and you're the owner of a company. You can choose not to cover yourself, and you might save a few dollars. Seriously, it might just be like $100 a year you're saving, $200 a year you're saving. I'm going to encourage you to ask yourself, what do I do if I have an incident? Okay, there is a very famous incident that we in this building know where a business owner of a business literally down the street from this building did not cover himself, and the man perished on the job. So the family had no comp benefit. So just want to put that out there for you. Okay, and this does potentially include internet businesses. Those are the folks who tend to be called the independent contractors most often, like let's say rideshare, for example. Well, just want to point out, the rideshare companies are carrying workers' comp insurance. So what that means is, let us make the decision. You're a worker, file the claim. It's always all right to file a claim. If your claim is ultimately disallowed, which means no benefits, that's okay. As long as you were truthful, there's no penalty. Let us sort it out. How do you know if a claims administrator or an insurance company is handling your claim? You could tell by the title. You could tell by the name of the entity. Or you could ask us, or you could ask your employer. It doesn't matter too much, really. The benefits are the same, and it doesn't really impact you. And your HR department is not going to have any say in the claim, probably, whether it's an administrator or an insurance company. That was me answering a question that came in that seemed on target. Okay, what do we do if there is an incident? This is a new topic. This is a major topic. This is what people need to know. Here's what you do, and I'm telling you this, okay? I'm the advocate for injured workers. I am here by appointment of the governor to tell you these things. So what that means is, if you hear something contrary to what I'm telling you, fall back on what I told you. Or check with us. You can check with us. We'll have the contact info, no problem. Okay, number one, what do you do if there's an incident? Get the necessary medical treatment promptly. Please go get care now. If your employer wants to drive you to an urgent care, that's fantastic. That's a very humane thing to do. Does the employer get to choose the urgent care? No. Does the employer get to come into the exam room? No. I'm only mentioning that because every once in a while I definitely do hear about this. But go get your medical care. Employers, if you want to help get the person to an urgent care, thank you. There's a place in a special place for you. Also, step 2, okay, workers, now you have to tell your employer in writing that you had an incident. Do that promptly. This is a very important step because it is going to begin the chain of events that is going to get you a complete claim, which is what you want. You want a complete claim. You want your claim to move forward. And we say in writing, so I'm recommending an email. You can even use a document. I'm not recommending that you text. You may legally text. It's just that I don't recommend it because I'll bet you don't know that your cell phone is only keeping your texts for 30 days. If you wanted to keep your texts longer, you have to change that setting. Did you know that? And also, see, you might be asked in 11 months to prove that you've notified. So if you never change that setting, it's not there. Okay, what's number 3? What's your third step? Well, now, I know you told the employer, but you may also file a C3 form, or you may also report to us. And we recommend you do that. We are showing you the online submission. There are some tabs that you would go across, but this is not hard stuff. Who are you? Who's your employer? What do you do on your job? What's your injury, illness? Let's click one and just show them how simple this is. Look at this. The date the injury occurred, time, if you know it, where. You know, these are not hard questions, but we recommend that you do this so that we know for certain there's a record of the incident. We're showing you the online. We love the online because it's immediate, it's clean, we don't have to read handwriting. However, if for some reason this doesn't work for you and you want to file the paper form, go on ahead. You can get the paper form from us, and no problem. I know that attorneys and professionals and providers, we're eliminating a lot of manual filing for them. We'll always take manual filing from workers because you're not system pros and we can't expect you to be. Continue receiving your necessary treatment, and remember this. Workers have 2 years after the incident to file Form C3. So you have to file within 2 years. There's a 2-year window of time. We are saying that you should report the incident to your employer within 30 days, but that's not filing the claim. There's a 2-year window of time to file a claim. Oh, Sarah's going to take over right now and give me a moment to breathe.
Sure thing. I'm just going to open our poll here. In this scenario, we're trying to see whether should Kadir file a claim. So Kadir is not an American citizen and is in the U.S. on a work visa. Kadir works 40 hours a week on site at a software company, and the company assigns him a desk, equipment, and tasks. He's paid on a 1099. The firm calls him an independent contractor, but one day Kadir is inattentive and drops a computer server, fracturing his left leg. The employer calls an ambulance that takes Kadir to a hospital. So in this poll, we're looking for a yes or no response. Yes or no, should Kadir file a claim? So once again, he's not an American citizen, and he's in the U.S. on a work visa, and he works 40 hours a week, but he's paid on a 1099. And he dropped a computer server on his left leg, and the employer calls an ambulance that takes Kadir to the hospital. So we're looking for a yes or no answer. I know typically here, when we have these polls, Joe's always looking for 50% participation in the poll, and we see that a lot of you are responding, so thank you. We'll keep looking for a few more responses here. And while you're answering the question, I just want to let you know, I know it's a question that usually comes in the chat regarding recording of this webinar. We are recording this webinar, and it will be posted to the board's YouTube page within the next few days. And we also will send an email with a link to that to everyone that is on this webinar. So,
thank you, Sarah.
You're welcome. Joe, we're just about at that 50%.
Great. I know what I think, so I'll share it. Yes, I believe Cadier should be filing a claim here because the circumstances we've given you are tilting that way. You know, he's going to the same place and he's doing the same task for the same people day after day with their equipment, and yeah, so that's starting to be like, hey, maybe he would be considered an employee. The firm calls him an independent contractor. That's nice. I hope they also call him a friend, you know, and a good employee or a good worker at least. But what the firm calls him is not driving whether he's going to get considered an employee or not. The board is going to make that call. And, you know, we have the citizenship angle. It doesn't matter, remember? It doesn't matter. All right. We're now going to discuss the benefits of our system. We have the medical, we have the lost wages, and we have the fatality benefit. We'll start with the medical first because, well, you need to take care of your health. We all do. So, medical benefits are available at no cost to workers. This is the medically necessary treatment for a worker-related injury or illness. This is a lifetime benefit. Lifetime. Okay, I'm stressing lifetime because every once in a while, a worker will ask us, hey, you know, my claim's closed and can I still get medical care? Well, if you did not take a very specific thing called the Section 32 waiver agreement, if you didn't sign that waiver agreement and permanently close your claim, which you would know if you did it, then don't worry about it. Your claim's open because workers' comp claims do not close routinely. They don't close just because a lot of time has passed. They don't. Okay. All these medical expenses are payable. Tests and surgeries and medical office visits and hospital care, inpatient, yeah. You have to be admitted to a hospital. Yes, for a work-related incident, you should be walking out. Hopefully you're walking out, yes, but you should be leaving the hospital without any cost. Also, we like to point out that transportation costs to and from the appointments for care are reimbursable. This on screen, thank you, Sarah, is the Form C-257. This is what you use to request the reimbursement for your travel to and from medical care. You see the left that says nature of expense? You're going to put physical therapy, and you're going to put the address where you went. And then you put the date, and then you put the mileage, and you're done. Okay, so it's really that simple. And you need to file these frequently, I would suggest. I would suggest file them frequently. Don't let them build up. Because sometimes, you know, you could have some things on the form that are not payable, and it could create some questions, and then possibly all your other services are getting delayed. So even if you're going to psychological care, that question just came in. Yes, psychological care is payable, and yes, you can get reimbursed for the travel. You can also use the same form to get reimbursed for travel to independent medical exams, IMEs, which we'll talk about in 2 slides. practice for medical care. Okay, I'm going to give you a little detail now, but this is critically important detail, and it's critically important for any healthcare providers who are on this session with us. At the beginning of a claim, you're in temporary world now. You have a temporary total or a temporary partial disability if you're getting the payments. So this is for people who are getting payments at the start of a claim. You're temporary, and you should be seeing your provider every 90 days at a minimum, because your provider is going to be stating your degree of disability. That's the second bullet. Your degree of disability is how disabled are you? And that judgment, that opinion, is used in calculating your benefit. I will show you how that happens in 2 slides. But the important thing is the providers have to give you a percentage of disability, or the insurance company can't do the math to create your benefit. So if you are a provider, please remember to indicate the degree of disability when you're dealing with a temporary disability. And also, workers, give your doctors a fighting chance to get paid for services. Arrive at all your appointments with the following pieces of info. Number 1, the WCB case number. We issue that. It'll be 8 characters. It'll probably start with the letter G, like glorious, if it's an incident within the last 15 years, okay? The insurer is also going to generate a case number. Bring the case number the insurer generated and the name of that insurer. Give that to the provider's office. They will love you. Now, I mentioned independent medical exams. I'm going to spend a moment on what they are, and I have some points of interest for you. The insurer is permitted to ask the worker to attend an independent medical exam. That is when it hires a physician, it's almost always a physician, to evaluate some element of your health or claim. Okay, here are some things you need to know. Number 1, you may bring a witness. This is one of those things where Joe's telling you this, you can count on it. Somebody says something contrary to this, don't listen, refer that party to me. Yes, you may bring a witness. You or your witness might record the IME. They might record the exam on that cell phone that you have. Video and audio. You do not need to tell anyone in advance about this. The reason you're doing this, you're going to get a copy of the report. If you don't get a copy of the report, you need to tell us. But you probably almost certainly will, and you can review that report. If you have an attorney, the attorney's going to review that report, and you can review it in the context of the video, because all the findings you see on that report, if they claim to have been taken at the exam, you should see them on that video. If you don't, check with the lawyer, because the lawyers are much more knowledgeable. They might see it in the video, whereas a layperson's not. But if no one is seeing it, now you need to tell me. You can make a complaint to the Advocate for Injured Workers. We will have our contact info on screen at the end. You're not going to miss it. You can tell us about any discrepancies in the report. You can tell us about conduct. You can tell us if the exam was not performed in an office that was appropriate for medical care. Those are reasons to make a complaint. If you disagree with the IME's findings, that's not conduct. You're going to have to litigate that. And also, you may claim your travel reimbursement. You would use the same form. Second benefit now, your cash benefit. We call it the cash benefit even though it's directly deposited, or some people still insist on a paper check. We'll get to that one. But this is the lost wage benefit, and the benefit is 2/3 of your average weekly wage. What's an average weekly wage? Well, it's how much you were earning per week on average. It's really that simple. We need to know what you were earning because your benefit's based on that, and we go back 52 weeks. All your compensation counts. Overtime counts. Bonuses count. All your compensation counts. If you had 2 jobs, you need to tell us about both jobs. That's another reason to file a C3, you know, because the C3 asks you that question. So you can get it all out right at the start. If you go to hire an attorney, the attorney is almost certainly going to want to file the C3 with you or on your behalf. That's fine. But we need to know about all your compensation. The maximum benefit for injuries as of July 1, 2025 is on screen. It's about $1,222. You'll notice from our slide that it just went up, okay? And that is as of the injury date. I'm sorry to tell you that there's no cost of living adjustment in our system either, so it's always going to be as of that date. And there's also a minimum. As of January 1st of this year, the minimum payment is $325 a week, or what the person was actually earning if it's less than that. So if you were, say, part-time and you were earning $300 a week, you would have a $300 a week benefit. But if you were earning $3,000 a week, you would, well, you could qualify for the minimum benefit depending on your circumstance. Well, scratch that example. Anyway, the point is that's your minimum. And that's going to be indexed. That's going to, next July 1st, that's going to change to 1/5 of the state's average weekly wage. There's a lot of math there, but the point is that is a thing that will help workers. That will change and move upwards every year, just as the maximum amount you can earn goes upwards every year. Remember I said the doctors have to file your degree of disability when you're temporary? Yes. So the claims start as temporary, and you're either going to heal, or you might have a permanent injury, which would create extended benefits, in some cases permanent benefits. Like, let's say you have a permanent partial disability. Well, then you could get benefits for a fixed period of time over the course of 4 to 10 years. If you have a permanent total disability, that means you can never work again. You could get the benefit payment for life. If you have an injury that creates a condition in a limb where you lose some of the use, that is known as a scheduled loss of use benefit, and that's going to be a payment. We like to call this out because workers who have an incident that impacts a limb need to know about this. Now, a limb is the following: an arm, a hand, and any finger. Each finger has a different benefit. And then the corollary is a leg, a foot, and a toe. Each toe has a different benefit. And we also want to make you aware that there's a vision loss benefit, there's a hearing loss benefit, and there's also a benefit for a facial scar. A facial scar can be up to $20,000. What you can do is you can visit our website and you can search publications. Okay, you can put it in the search bar, or you could go to the bottom and you'll see publications of the screen. Go to the bottom of the screen, you'll see a link for publications. This is something that Sarah and I have worked on, and we have all of these publications, dozens and dozens of them, that explain elements of the system, such as your benefits. How about the best practices? Well, not to belabor this point, but I hinted at it earlier. If you can get a bank account, would you please consider using direct deposit? If you get a bank account and then you get direct deposit, you will not be inquiring of anyone, the insurer or my office, where your check is. It's really that simple. I don't know why you don't sign up for direct deposit if you can get a bank account. And finally, if you get paid in cash, that's okay. Keep some records, please. You're going to need to know how much you were getting paid so we can calculate that benefit. You're going to need to know how much for the past year. So keep some records of who paid you and how much for doing what, on what day, because you're going to need those records if you ever file a comp claim. The final benefit we'd like to talk about is the fatality benefit. There are two elements to the fatality benefit. This is for a worker who perishes on the job or who has a consequential death, as in an injury or a disease, and then over the course of time, it eventually took the worker's life. So the first benefit, the first element in the benefit is the funeral and memorial expense. It's payable two different amounts. Downstate, in the classic New York City metro area description, which is the 5 boroughs of New York City, Long Island, Westchester, and Rockland. That whole area, up to $12,500, is reimbursable. So you're going to have to do the funeral and memorial with the funeral director. You're going to have to get a bill, and then you submit it, and it's reimbursable. In the rest of the state, $10,500 is reimbursable. The second element of the benefit is the weekly payment, which comes every 2 weeks, to the surviving family. So there's a bit of a hierarchy. First, we look for a spouse. The gender is not relevant. Then we look for children up to either 18 or 23 if they're in a program of higher education, accredited. And then we look for disabled or blind dependents who could qualify for life. The spouse can also qualify for life unless the spouse remarries. Then the spouse gets a 2-year check and the benefits end. All these people are sharing the same benefit. They're sharing the maximum amount the worker would have qualified for, but they're sharing it. And if they drop off, the other party's share could increase. If none of these parties exist, a single person, no children, then $50,000 is payable to the parents. If none of those parties exist, $50,000 is payable to the estate, and that's where the comp benefit ends. Anyone else who's in line to possibly receive from the estate needs to contact the estate. We would like to show you two nonprofits who have a benefit of scholarships. Okay, this is now Kids Chance of New York. This is a national nonprofit that has a chapter in every jurisdiction, including New York. They give scholarships, and we're showing you their webpage here. I happen to know they have scholarship money available, and it is July, so did you work out how you're paying for college yet? it's definitely okay to get in touch with Kids Chance and see if they can help you even this year. Even if you already worked out how you're going to pay for it, maybe Kids Chance will help you, and then you pay less through the other sources. The other organization we'd like to point out to you is the Triangle Shirtwaist Factory Fire Memorial. They also do scholarships for the children of workers who, the workers were either killed or were grievously injured. That's both of these, okay? Yes, killed due to employment, but grievously injured will also possibly get you a scholarship. And you can see some of the institutions right on screen here who've gotten payments. That's a pretty good list. So we'd like to encourage you to contact these organizations directly. We are not involved in a formal way, but we do make you aware of their existence because of the value of their efforts here. And now, Sarah is back.
Hello. Open the next poll for us here. In this scenario, we want to know what is the proper benefit amount. Liz worked full-time as a bartender at an upscale restaurant. She also worked some mornings at the family hardware store. Liz had a serious incident with a box cutter at the hardware store. She missed 4 solid weeks of work from both jobs and was rated 100% disabled by her treating doctor. So in this scenario, is a true or false? Because she was hurt at the part-time job, Liz's benefit will be based on her earnings from that job, and the restaurant pay and tips are not included. So once again, because she was hurt on the job, the question, we're looking for a true or false answer. Because she was hurt on the job, her part-time job, Liz's benefit will be based on her earnings from that job, and the restaurant pay and tips are not included. See that a few of you, we can actually see on screen people that are participating. And as I mentioned before, Joe is usually looking for that 50% mark.
Yes.
So for all of you that are answering right now, thank you very much. And we also like to take this time to let you know, we do see that there are some questions in the chat that Joe will get to at the end, but we'd also like to encourage you to start putting any other additional questions you have in there for us as well. Well, for Joe, the expert.
I'm sorry, but I do remember you did answer one that I didn't know.
Yeah.
I like to think it's a team.
There we go.
Thank you. Wow, look at that. We passed 50%.
Yes, we did.
All right, team. You can keep answering, but according to the way we phrase the question, true or false, we're saying she has 2 jobs, but her benefit's only going to be based on the one job where she had the incident. That's false. You might remember earlier. If you don't, I'll just restate it. Yes, remember I was saying, tell us about both of your jobs? Yes, this is why. Because even though Liz got hurt on the family hardware store job, which I'm going to presume, since that's part-time, probably lower earnings than the bartender at an upscale restaurant. We're telling you upscale to indicate maybe she's earning, you know, at the higher end of what a bartender would earn. And we even let you know that there's the restaurant pay and there's the tips. So yes, in this case, her benefit would have been based on the earnings from the hardware store, the paycheck from the restaurant, the tips from the restaurant as well. All right, let's move on to, well, the wrap-up period. Okay, we're kind of in the wrap-up now. We have a few more things to let you know. There are penalties for late payments to workers. The benefits have to begin for a worker who can't work or has some disability. The indemnity payments, the cash payments, must begin within 18 days of the incident or 10 days from when the insurer got notice or the employer got notice, whichever is later. Okay, so there's a pretty quick turnaround on when benefits have to begin. And if they don't, a penalty is possible. Some of these penalties are payable to the worker, by the way, such as this one. Let's say there's a hearing and a decision is created saying pay the worker. That payment has to be released within 10 days of when that decision is filed. If it's not, if it's 12 days, even if it's 12 days later, a penalty is possible, and that one is payable to the worker. That's a substantial one. Also, this is why I keep harping on direct deposit. Your check for your 2-week payment is not late until it's 25 days late. And also, if there's an appeal, well, interest can be due. So if you're a payer, you get that appeal decision and you have to make a payment, you need to calculate that interest and pay that interest as well, if you wouldn't mind. All right, workers, you do have some responsibilities in this system beyond just trying to heal. You should try to come back to work as soon as you're physically capable. That is for several reasons. Number one, if you can come back and go on full pay, you're going to be bringing home more money. And secondly, your employer, if your employer is what I like to call enlightened, well, they might offer you light duty or transitional duty. And that's a way to come back and get back to full pay, even if you have a low degree of disability. What happens is your doctor can state some physical requirements or restrictions, I should call them restrictions, physical restrictions to your performance. Maybe you can't stand for more than a certain length of time. Maybe you can't carry more than 5 pounds. But if the doctor creates those physical restrictions, you can give them to the employer, and the employer could possibly accommodate them and bring you back. Also, if you change your mailing address, would you please let us know? And if you're going to make any agreements, like a Section 32 waiver agreement, for example, try and understand it for real and work with your legal rep. Also, sign up for eCase. Oh my gosh, I love eCase, and I love when the workers have eCase access. We're showing you right here the process you undergo to get eCase access. I mean, look at this. You make those clicks. Here's what you do. You fill in this very easy, minimal information, and then you have access to all of the records in your file. So now you can see what everybody else sees. And you do this per claim, by the way. If you have 2 claims, you need to do it for each claim because you need to give us each claim number, and you get access to each of those claims. Oh my gosh. Self-empowerment. It's a beautiful thing. Okay. What happens if there's a hearing? What should you reasonably expect? Well, here it is. You could have a hearing, and it's going to be virtual. So you and your rep attend the hearing. I'm telling you, you should attend this hearing and don't expect to be participating actively. Don't expect to be talking unless you're asked a specific question by the judge, okay? Other than that, if you have a lawyer, your lawyer's representing you. That's why you have a lawyer. If you don't, well, then you will have to represent yourself at the hearing, and the judge will make some findings. There could be witnesses. The board does not use the formal rules of evidence and procedure that courts use, like you see on television, or if you've ever been in a court. We don't use the same formal rules because, number one, we don't actually operate courts. These are not courts. This is called administrative law. But just because it's a little less formal that way doesn't mean that all the parties do not exercise the same decorum that happens in a court. because they do. And as I indicated, the hearings are virtual. It is possible to come in for an in-person hearing. It's just that you're going to have a virtual hearing first, and then at the virtual hearing, you're going to have to ask the judge if you can come in person for the next hearing, if there is a next hearing. If all your business is wrapped up at that virtual hearing, we're not going to have another hearing just so you can come in for it, because there's no purpose to that. The Injured Workers Toolkit. Boy, we love this one. We have collected all of the materials that injured workers probably need to know about and put them on one page on a website called the Injured Workers Toolkit. So we're showing you right now the screen and some of the items that are on there. I mean, we go through what's your medical care. We have a lot more detail now than I gave you right now. And look at survivor benefits, that's the fatality. We have so much info available there for you. So we're recommending, if you're an injured worker, you check out the Injured Workers Toolkit on our website and see, you know, what resources we have available to you that maybe you didn't know about. These are our social media presences. The fifth one down is LinkedIn. If you have LinkedIn, would you like to work for the state of New York? If you do, or if it might be something you're interested in, we suggest you check out our LinkedIn, because the New York State government is making a big push to refill its ranks. We are having that same demographic situation everyone else is having. People are leaving and retiring. We need to fill these spots. And we also have something called New York Helps right now, which means we're posting jobs and you might not have to take the famous New York State Civil Service exams. So go to our LinkedIn there and check us out, okay? All right, this is the contact info for my office. And at this point, I'm going to turn it back over to Sarah for a moment, because she's going to tell you about questions.
Sure. So we did see people have been putting their questions into the chat, and thank you for that. If you have additional questions, this is the time to get them in here. We're going to take a brief pause to look through the questions, and we will be back with some answers. I will leave this up so you can either take a screenshot or write down the contact information. And like I said, we'll be right back.
All right, everyone, thank you. We have a good many questions, so we'll be here for a little bit, and that's perfectly okay. And if you have more questions, go on ahead and type them in. Just to lead off, a general question about immigration status. Remember, regardless of whatever is happening in the country about immigration, the New York State Workers' Comp system, immigration status is not a factor, period. Thank you.
Okay, Joe, our next question, or our first question here for you is Sedgwick an insurer or a claims administrator?
Sedgwick is a claims administrator, and we're happy to answer that question only because Sedgwick is, I think, the largest claim administrator in the country. So lots and lots of employers and carriers are using Sedgwick.
Okay, great. Our next question here is, what happens if after surgery you're still in pain and the therapy does not help either? What are your next steps or options? Okay,
there's a very simple answer here from my perspective, and I say this with peace and love. Go get care. Go back to the doctor. Go get care. That is not actually a workers' comp question. That's a medical question, and we don't want to hear that you're in pain. Go get care, please.
Okay, next question. If you notified a job of a medical injury sustained at work and the employer did not offer you workers' comp or educate you on your rights, what can you do? Do you have the right to report this past the 2-year mark?
Excellent question. The employer does not offer you workers' comp. The employer's responsibility is to tell its insurance company. So to this person, to this worker, number one, why don't you use that contact info there and contact our office and ask us if there is a claim for you, and give us the following information right off the bat, please. Your name, your employer's name, who you worked for when you had the incident, and the approximate date of injury. Let us look it up. There could be something there and you just don't know about it. Now let's address the last part of it. The last part of it is, do I have the right to report this past the 2-year mark? Assuming the incident happened more than 2 years ago. Yes, of course you can report it, but are you going to get benefits because you're aware of the 2-year window of time? Well, there is an element of the system that says if you're reporting it to us, for the first time after more than 2 years from incident, there's something called the advance payment of compensation. If the employer or the insurer made an advance payment of compensation to you for this incident, then your claim could be brought into the system. What's an advance payment of compensation? It's a payment in consideration of the incident. Did you get any money because of this incident? If yes, well, you could make the case that it's an advance payment of compensation and the claim should be brought in.
Okay, so our next question here, if you accept a settlement or close a claim, can you claim another injury down the line in the same area?
Yes. So this is someone who, and I'm going to change the question, okay? And I hope the person who wrote the question is listening because we have to be precise. A settlement is one thing only in this system, a Section 32 waiver agreement that permanently closed the claim. There are people who get a payment like an SLU payment, or they didn't get a payment for a year and then they got one big payment. They call that a settlement. That's not a settlement. So, assuming you actually took a real settlement, a Section 32, you can continue a claim if it's for a different incident. So let's say you took a Section 32 for your arm, and then a year later you had a severe laceration to the same arm. That's obviously a different incident. So this is one that you can maybe check with my office, and we might want to be specific in your instance, but I do hope that everyone else is listening to the point where don't call it a settlement unless it's a Section 32 waiver agreement that permanently closed it. Number two, maybe come back next Monday, because Sarah and I will be back next Monday.
Yes, we will.
For the Workers' Comp 202, where we do talk about that. And the same person has asked a corollary question that we're just going to address right now, which is, suppose you're working through your comp claim. Well, you know what? That means that you didn't have a total disability. Maybe you had a partial disability, or maybe you had a 0% disability and you were getting your medical care. That's something that is allowed and expected, frankly. If you have a 0% disability, you're certainly entitled to medical care, and we would certainly expect that you would be working if you had 0% disability.
Okay, great. Our next question is medical documentation required every 30 days while out on leave?
No, it's every 90 days. However, do you have some sort of a collective bargaining agreement with your employer that asks for 30 days? I don't know. Maybe you do. But within this system, to continue receiving the lost wage payments, it's every 90 days. That's the system rule.
Okay, and we had a follow-up question from the same person. Also, how exactly does the payment work for those who have 50% degree disability and choose to return to work with light duty or alternate assignment?
Okay, this is a great question because it's opening up two different avenues. All right, let's say you have a 50% degree of disability and you return to work with light duty assignments. So you're working all day, every day? You're working full-time? You should be getting your full-time pay. End of story. Let's say, though, that you return to work and you're not working full-time. You might be eligible for what's known as the reduced earnings benefit. Would you kindly type reduced earnings into the chat? So Sarah's putting the name of the benefit into the chat so everyone can see it. This is something that you can, thank you, that you can claim if your injury allows you to work, but you're earning less than your pre-injury wage. You're earning less, but you are working. So you can get a reduced earnings benefit. The reduced earnings benefit is going to be 2/3 of the difference now. What happens if you never got benefit payments? Okay, someone has asked a very brief question here. What happens if you never got benefit payments? Well, why didn't you get benefit payments? Did you not get benefit payments because you were not disabled, or what was the reason? Essentially, here's how I'm going to answer that question for that person and anyone else along the same lines. Contact my office, please. Give us your claim number. Let us look it up, see what happened, and then maybe tell you what you might be able to do.
Okay, our next question here. Person was offered a Section 32 settlement and they did not take it. They want to know what their next steps are or what they can do.
All right, you were offered a 32, Section 32 waiver agreement. You didn't take it. That puts you right back to where you were. So your claim shall continue. If you are missing benefits that were deferred because you were going to take a 32 and you didn't, you should be going after those benefits now. If you need help, number one, maybe get yourself an attorney. Number two, if you don't have an attorney and you can't get an attorney, or you just want to double check, contact my office, give us your case number, we'll look it up, and we'll take a good look at what's happening, and then, we'll tell you where you stand.
Okay. Next question here. What is the time frame for starting payment after injury?
18 days from incident or 10 days from notice. If you have a disability that's more than 0% and you're not working or your ability to earn has been impacted, 18 days from incident, 10 days from notice.
Another person here who wrote in about a case that is in appeals, but it's actually through the Longshore Act. Would you like to touch base on that?
I would. So, to our merchant marine, whose case is covered under the Longshoremen's Act, you are not in this system. We do not, we don't do, that's a federal claim, or it's a claim that's payable under the Longshoremen's Act. Because you're a merchant marine, you are not a member of this system, so yeah, there isn't anything we can do for you. Sorry.
Thank you. And our next question here, this person asked if you are an injured compensation worker and you're still working on the job, making close to $300 per week, would you get less than the minimum payment of $325 per week as indicated on the slide?
Yes, if your true pay was less than $325 per week and you needed an indemnity, you would be receiving your true pay. You wouldn't be elevated to more than you were earning with that $325.
Okay. Our next question here, how long does the insurance company have to pay travel reimbursement expenses?
Excellent question. I apologize that I didn't address that because I frequently do. All right, travel reimbursement. Number one, there is no time limit for how far back you can go to submit. So you can go all the way back to day one and submit those expenses, those travel expenses, even if day one was a long time ago. But there is no time parameter for how quickly the insurers must pay those expenses back to you. You know, they tend to try to do it within 30 to 60 days, and that's just me giving you my experience. They tend to try to, but there is no time parameter for when they must do it. So, you know, if it's going on a while, you could check in with the insurance company, you can check in with us, and we can see what's in the file, and we could make a contact for you on your behalf as well.
Okay, our next question here, if your injury involves neck, back, and knee, can the 10 visits allowed for physical therapy be used as 10 visits for each body part?
All right, we have a knowledgeable worker here. We have a knowledgeable worker who is talking about the 10 maintenance visits for physical therapy that are allowed per year. Okay, this is not where it's a new injury and you need physical therapy. Because if it's a new injury, let me address that first because that's easier. If it's a new injury, someone's going to prescribe you PT and then you're going to get a very explicit decision. And yes, you could get 12 visits for a back and you could get 12 visits for a knee because they're different. Or you could maybe get them both at the same visit as well. So for the maintenance visits, I think that there are 10 maintenance visits per body part. So you can double check that with the medical director's office, that's for sure. But I think that there are 10 visits per body part. But if I was you, I would maybe double check that with the medical director's office. I'm sorry, I don't always have every answer off the top of my head.
Okay, our next question here is, if you get hurt while returning to work from a work-related training and get medical care but don't receive the therapy, but you're still suffering from the injuries and continue to work, can you now put in a claim?
You mean you didn't put in a claim when you got hurt? Yeah, I would say if you got hurt on the job, you need to tell your employer and file a C3. Here's the threshold. More than 2 incidents of first aid. First aid is a Band-Aid. First aid is an aspirin, okay? That's me giving you a very off-the-top description of first aid, but I want you to know that it's really that light is first aid. Essentially, if you have to see a healthcare provider, you've almost certainly exceeded first aid already. And once you get to that appointment, the healthcare provider will tell you if you've exceeded first aid. So get yourself some care and tell the healthcare provider it happened at work so it could be billed under workers' comp. Okay, Sarah, let me just do this one. Mm-hmm. Someone's written in and is complaining about the lawyer, complaining about the judge, complaining about the pay reduction. You know, if you have a claim and if you go through the system and if the judge finds you less disabled than you think you are, or even less disabled than your doctor said you are, you have two options. The first option is you can appeal the judge's decision, but you need to do it within 30 days of when the decision was filed. If you did not do that, that's how it turned out. That's how your claim turned out. So I'm sorry if it's not a very satisfactory answer, but sometimes we get decisions in the system that are not what we expected or what we hoped, or the judges disagree with our treating doctors, and that is how it goes.
Okay. Our next question here is, could you explain the C2 process?
Thank you for reading that precisely, because there is no C2 process. So to our friend who's written in, our friend has written in a few times and wrote in this morning actually to the office, and hi, I recognize you, and that's fine, okay? We're happy to hear from you. Could you please clarify, there is no C2 process. Just for ancient history's sake, C2 is what employers used to file years ago. There is a C3 process. If you mean the C3 process, that is the name of that form that we keep showing you that workers file to report an incident. And it looks like I guessed it right. Thank you for clarifying. Thanks for pointing it out. Yes, the C3 process is when the worker reports a claim or an incident. When the worker reports an incident, it's very simple. Step 1, come to our website. Step 2, click File a Claim. There's a button at the top of our screen, File a Claim. Click it. You now have the C3 online version. Fill it in, hit Submit. That is what you do if you do not have a claim. That is what you do if a claim was just filed, but you want to state your side of events. That's what you do. You only need to do that one time. Okay?
Okay, our next question here is, can you go back to work and take time off at a future point and be entitled to disability? And does that, second part of that is, does it have to be light duty?
Can you go back to work after incident? Yes, presuming that you're able to. Can you take time off at a future point and be entitled to a disability? That is not how we describe it. Let me just explain when you don't work, because that actually answers your question. You're going to be relying on your treating doctor's opinion of your disability. If the treating doctor says you're 0% disabled, if you don't go into work, you're not going to get a comp benefit. And you're going to have an extraordinarily difficult or maybe impossible time litigating yourself to a lost wage benefit if you don't have a doctor who's saying you're disabled. So there is that. But let's change your question a little bit to this way. Let's say you return to work and then you need a surgery and your surgery is approved. Okay, post-surgery, you're going to need some time off to recover. Your benefits can resume at that point because you had surgery and now we know officially you have a degree of disability. I think I just answered that.
You did.
All right, we're taking a look at something that just came in. Okay, yes, we can, yes.
Okay, this one here?
1229. Oh, 1220, oh, it's the same. Oh, no, okay, do the 1228, please.
Okay.
And I'm very sorry, the questions come in quickly and the screen moves.
I have had a fall after work and I fractured my foot. Now I'm no longer employed.
What do I do?
Yes, thank you.
Okay. you had an incident where you fractured your foot. I'm sorry to hear that. I hope you're getting care. And the worker was terminated from employment. Okay, so we have two things here. I'll address the termination second. The first thing is the benefits. The fact that you're no longer employed is not relevant right here in your claim. Get your care, and if your treating provider says you can't work right now, you're eligible probably for the lost wage benefit, even if you were terminated, okay? The lost wage benefit is based on how disabled you are. Notice how we keep coming back to that. We keep coming back to, did the treating doctor say you were disabled, and how disabled, okay? That's the key thing. So if yes, you should be pursuing that lost wage benefit. The other element of this question I'd like to address is the termination. Your employer may not terminate you because you filed a comp claim. Your employer may terminate you and hire somebody else to do your duties because those duties need to get performed in your absence. That is permissible. So this is a fine line of the comp system, but it is a fine line of the comp system. And I would hope that employers, just for a humane perspective, this is me just asking you, give your workers a chance to heal and come back. And, you know, it could ultimately be actually helpful for your workers' comp anyway to bring somebody back.
Okay, another question here. Is the C3 automatically filed by claims administrator, or do you need to file it with the board?
I'm not being picayune here when I say the C3. The C3 is only filed by the worker. However, if you're asking me, does the claim administrator have to automatically file a notice when there is an incident? The answer is yes, big time, or there's a penalty. There's no penalty if the worker doesn't file. There's a penalty if the claim administrator does not file. It's just that that's not called a C3.
And this one up here, I was saving this for Joe. I think this will be our last question of the day. Someone was asking if we were to give more informative or more information in their future webinars for injured workers. I think they like what they're hearing and they want to hear more, Joe.
Yes, we love getting this. Thank you very much. Thanks for the nice information you said. But also, do we have more informative webinars? Yes, we most certainly do. We, as an agency, I don't know, what do we do, like 3 or 4 webinars a week, maybe, yeah. It feels like?
It does some weeks, yes.
For my part, for the workers, I do every month with Sarah, I do the Workers' Comp 101, which you've just enjoyed, and we also do the Workers' Comp 202, a deeper dive. So that one goes into more detail on all of these topics, and our next one is Monday, July 14 at 10 a.m. So if you want to come back for that one, would you kindly go to the webinar page of our website and register, and then we'll be talking to you at the next one. Oh, look, we got one more, Sarah.
Okay. This is, I think, a follow-up to your C3 question that you had before. Does a worker need to file a C3 if the employer filed on their part?
You do not need to. It is not mandatory, but we do suggest that maybe you want to, because, you know, it's you saying your version of events, but also there's that whole element about having 2 jobs. And so that is something that you would tell us about on the C3, because your one employer might not know that you do work at the Family Hardware store a couple of mornings a week, or they might not know how to tell us about that. And that's going to be very important info for your claim. And Sarah has just typed in the address for the medical director's office, mdo@wcb.ny.gov. I promise you that is a legitimate and correct address. Just always remember, folks, when you're dealing with us, we're the government, so we're a .gov.
Okay. Well, Joe, I thank you for your time. I know that there's some people that you may think that we didn't address your comments. What I want to point out, some of them are very specific in nature, and we would prefer that you reach out to Joe's office directly, and they can address anything like that. There is some personal information, other stuff in there, and we would much rather deal with that offline. So we really thank you very much for joining us today. Thank you, Joe, for your time and all your expertise and your knowledge. Just a reminder, you can also sign up to receive workers' compensation news, including information on future webinars, straight to your